We're waiting for Yorgos to sit. By the way, όσοι δεν έχουν βγει χειμών έξω, έχουν χάσει. Γι' αυτό έχετε μια δεύτερη ευκαιρία μετά από το session που θα ακολουθήσει. Λοιπόν, γεια σας. My name is Maria Georgiadou and I'm the Managing Director of Cyprus SEEDS. You know all about Cyprus SEEDS by now. All I wanted to say is welcome. I know it's very difficult in the afternoons. You already have worked and you're probably tired, so thank you indeed for being with us. All I wanted to say is a very big thank you to our host, Cyprus Institute. We are extremely pleased to be collaborating with the Cyprus Institute to offer this workshop to you, the community, and there will be more. All I can say is that there will be more to today's and yesterday's seminar. Thank you also to the USA Embassy. I had to say that as well. I know you heard it yesterday, but without them, we wouldn't have been able to have this wonderful team in Cyprus. Not one, not two, not three, four, I understand. There was a surprise yesterday, and I'm sorry I missed it. So thank you very much, Spiros in particular. Spiros Haridou from the Embassy of the USA has been instrumental in getting a sponsorship from the Embassy to bring this team to Cyprus. And finally, thank you, Tim from K&L Gates. It's only the beginning of a road which we wish to walk with you in supporting the monetization of innovative research coming out of the universities of Cyprus. So thank you for being here.
So, good afternoon, everyone. Thank you for coming back for a second day. I hope you found day one enjoyable, entertaining, and informative. As you may remember, my name is Christopher Valente from our Boston office at K&L Gates. With me is Alessandra Feller from Milan and George Summerfield from Chicago. I think we have two great topics to cover today, a lot of ground, and importantly, and I'll stress this, if you have questions, feel free to shout them out during the presentation rather than waiting till the end. We'll have time at the end as well, but we want this to be a little interactive. Particularly, these issues today are probably going to provoke quite a few questions throughout the afternoon. So with that, I'll turn it over.
So good afternoon, everyone. It's good to be back here. Today, we're going to talk about a couple of different topics. Better. The first is going to be patent procurement. In other words, you have an invention now, what do you do with it? And then the second part, kind of chronologically logical, is what do you do about things like ownership and licensing? So once you have a patent, what do you do with that? Before we get into the substance of patent procurement, I just wanted to make an overall comment, because in addition to this seminar that we've been putting on, we've had the chance to visit several institutions engaged in research in a variety of technical fields. And at those different institutions, we've gotten to meet the researchers and have become acquainted with a number of the different research projects that those researchers are engaged in. And the one thing that I think has struck all of us is just how much is going on here. It truly is incredible. And so I think that this patent talk is very timely, because I think the challenge is, given the amount of research that's being done and the obvious quality of that research, how do you move to the next step? How do you go ahead and make sure that you have the requisite intellectual property protection in place? And then also, how do you avail yourself of the value of that technology in the marketplace? So with that in mind, let's start talking about patent procurement. This is the process by which you go to whatever patent office you seek to obtain a patent from to file an application and convince that patent office that what you have is actually patentable. So actually the patent procurement process starts well before you actually file an application, as you may imagine. as we talked about yesterday, a patent application is originally owned by an inventor. And the term inventor has a very specific meaning. It means that that is the person that actually thought up whatever the invention is, or contributed some inventive content to that invention. So an issue for any patent applicant is being able to prove that he or she is in fact an inventor. And you can't do that by simply saying, yeah, I invented it, trust me. There has to be some evidence there at the end of the day. And so first and foremost, when someone is engaged in research that is likely to lead to inventive activity, that person really should engage in a proper record-keeping function. Now, some institutions may in fact have in place policies that dictate what those records are supposed to look like, but to the extent they don't, there are a couple things that you want to keep in mind. Number one, if you're engaged in inventive work, then chances are you're keeping notebooks, or you're recording what you're doing somehow, whether it's by hand or by computer these days. So you want to make sure that those records are accurate and detailed, and that they are sufficient enough so that 10 years later, if anyone is questioning inventorship, they can go back and look at what you recorded and can follow what it was you were doing, when you were doing it, who you were doing it with, etc. Very important. Secondly, invention disclosure. So once you have all this raw information in your notebooks or whatever else you're keeping records in, you want to be able to distill that down to a document that someone can read and understand what your invention is, why it's inventive, what problem you were trying to solve. And again, some institutions have forms of invention disclosures, others don't. But in essence, an invention disclosure should really be your first attempt at describing as precisely as possible what it is you have invented, so that someone can take that invention disclosure somewhere down the line and turn it into a patent application. I've seen on more occasions than I can count a real disconnect between what the inventor actually invented and what turned out to be the patent application. I've had patents that I've litigated where the inventor has said, that's really not what I invented, when he or she read the claims. And that's really distressing because, frankly, you kind of have to have the inventor buying into the patent as describing his or her invention in order to make it truly enforceable. So from the standpoint of, let's talk about now companies that are engaged in an effort to commercialize intellectual property. Basically, especially if you're a startup, you don't want to squander resources on things that aren't really within the company's business plan. For universities, it's obviously different because portfolios can vary widely between technology and technology. But if you're a company trying to get traction in the marketplace, then you want to conserve your resources, and you have to make calls about what it is you're going to file patent applications on. So if your company's engaged in small molecule research and someone says, hey, I have this oligonucleotide that I think might be very useful, well, that may be true, but if that's not what your company's technological sweet spot is, I think it may be worth thinking about whether that's something you want to spend money on to seek patent protection for. And as a prerequisite to that, obviously, you kind of have to define what your business goals are. What is it you are intending to do? And I think for a lot of companies, especially where the driving folks behind it tend to be scientists rather than business people, that's often an afterthought. And so setting your business goals, what is it we're trying to do, and how does our patent procurement strategy fit into that, I think are two key issues that have to be addressed right off the bat. So patents can be expensive to procure. And again, for a startup company, you don't want to be wasting money on things that won't end up being patentable at the end of the day. So doing a prior art search may be advisable. We talked yesterday about what prior art is. It's basically everything that came before a patent. And patentability is evaluated in part by comparing the invention to the prior art. So if you do a prior art search and you find, as people often do, that what you've invented has actually been invented before, you have a choice. You can either amend your claims, change the scope of your invention, make it narrower, or not bother filing a patent on that and moving on to something else, because basically you won't be first. You won't have anything patentable that then you can commercialize in industry. So a prior art search is an important thing. There are companies out there that actually specialize in prior art searches. They effectively perform it as a commodity service for companies, and they charge a flat rate for doing so. A lot of them are based in India, elsewhere. It's also possible to discuss patentability searches with law firms. They do that all the time. They search through the prior art, and they give you an idea of what the prior art status is and whether you actually have something that satisfies the novelty and inventive step requirements of patentability. The prior art also tells you whether you have freedom to operate. And what that means is you get a patent that issues, and we talked about this yesterday, you get a patent on elements A, B, C, and D, but there happens to be a patent out there that pre-exists yours that claims A, B, and C. Well, you add D, it's inventive and it's novel, but to practice your patent you still have to do A, B, and C, which means you're infringing the earlier patent. So you perform all this research, you go to the trouble of obtaining a patent on whatever it is you've invented, and then lo and behold you can't do anything with it because there's a pre-existing patent out there that covers a more fundamental invention that you would infringe if you went ahead and practiced your own invention. So the two components here, patentability and freedom to operate, I think are key. They're a key strategic element in determining what to file for patent protection on and what not to. Identifying filing jurisdictions. We talked about this yesterday. Patents are territorial. So, and there is a cost associated with every patent application that you file around the world. So for the same invention, if you file in 20 different countries, you will incur 20 different costs associated with those filings. Again, subject to changes like the unitary patent protection that Alessandro will talk about in a little while. So you have to ask yourself, where do I want to file? And the key element there is, well, where do I expect it to have the most value for me? So if you have an electronics patent that's directed, say, for example, to a chip pair for communications in a cell phone, then there's a high likelihood that China is going to be one of the countries that you'll want patent protection in. If you have a pharmaceutical patent, well, obviously one of the biggest markets is the United States, so you're probably looking at filing in the United States at some point. So where is your competition going to be? Where are your licensees going to be? Where is it that your exclusive rights will make the most difference? So now we've kind of figured out, generally speaking, what the approach to patent protection is going to be. So the next category of, I guess the next topic for discussion is the types of patents. Not all patents are created equal. There are various forms of patent protection, and it's worth taking a look at each of them to determine which makes the most sense for a particular invention. Now, in some cases, you're not going to have a choice, but where you do, it's worth at least thinking about it. So the most common type of patent is what's called the utility patent, and it is a patent on a new and useful product. And basically, the patent we looked at yesterday with the anti-eating mouth guard, that's a utility patent. It is a device that has a use, right? And utility patents can be directed to products, they can be directed to methods of manufacturing products, and they can be directed to method of using products. So any one of those categories is amenable to utility patent protection. Generally speaking, those things have a valid life of 20 years from the date of priority application, and it gives you, as with any patent protection, the right to exclude others from making, using, selling, importing, offering for sale the subject matter claimed in your patent. Design patents, unlike utility patents, are supposed to be directed to the ornamental features of an invention. So the non-utility features. And it's a common misconception that you can't have a design and a utility patent on the same thing. You can, they just have to be directed to different aspects of the same product. So if you've invented a new and useful widget that also has inventive ornamentation to it, You can get a utility patent on the utility of that widget, and you can also get a design patent on the ornamental aspects. The biggest problem people have when seeking design patent protection is segregating the ornamentation from the utility, and that's where a lot of times design patents run into validity problems. Next are plant patents, and these are directed to varietals, reproducible varietals of plants. So you have to have come up with something that via the hand of man constitutes a new and inventive plant variety. These tend, as you can probably imagine, not to be a widely sought form of protection. Sorry about the feedback. There's a small minority fraction of plant patent applications filed. Try it again. Okay. And plant patents are not available everywhere. So primarily these are forms of protection that are available in the United States and Australia. Finally, we have petty patents. Those are things that are not, for lack of a better term, full-blown patents. And these include things like innovation patents in Australia, utility models in Germany, Korea, and China. And in most instances, these kinds of patents have an expedited prosecution time frame. They issue very quickly. They're not subject to formal examination. So basically all the patent office is doing when it issues one of these things is looking at the formalities. Have you included all the bells and whistles necessary to make an entire patent? And that's pretty much it. They also have a shorter lifespan. So in Germany, for example, a utility model is valid for 10 years. And so when you're looking at these things, you have to ask yourself, what is the likely commercial shelf life of my invention? And let's face it, with the exception of new pharmaceutical products, the vast majority of inventions out there are not going to be commercially sold 20 years from now. So in most instances, a 10-year patent life may be more than enough to protect the commercial value of whatever it is you've invented. So where you have the option of one of these petty patents, it's worth looking at. And in most jurisdictions, you can file an application for both. So you get a petty patent in the first instance and then a utility patent, a full-blown invention patent in the second instance. And I should say, by the way, for the startup companies out there, these kinds of patents are very useful in the first instance to attract investment. I mean, one of the things investors want to know is what intellectual property do you have? And if all you're doing is filing for utility patents, the answer may be none for a period of several years, depending on where you file. These forms of patent protection give you something you can show investors almost right away. It's a matter of months. And by the way, they are enforceable against infringers. I mean, there are certain presumptions that you don't get with these things, like validity, but it's still a patent that you can enforce. You can bring suit. And as a matter of fact, in the cell phone wars between Apple and Samsung, Apple made effective use of the Australian innovation patents by bolstering its patent portfolio with these things and then bringing suit against Samsung in Australia for infringement of those patents. So a question came up yesterday about patents versus trade secrets. And this fits into the discussion about what kind of protection you really should be looking at. Because there are some instances where it doesn't make sense to file patent applications, but rather maintain inventions as trade secrets. So why would you do that? Well, it depends on the situation, but if we look at the pros and cons of patents versus trade secrets, let's start with patents, right? So as we talked about yesterday, it's a bargain with the government where you tell the government what you've invented, and the public for that matter, and the government gives you exclusivity. So you have to disclose your invention so everybody knows about it. And when your patent expires, everybody gets to use it. It's limited duration, so it doesn't last forever. It expires. It requires government evaluation. In other words, you don't have a patent until the government says you do. And it protects against independent creation. So as we talked about yesterday, if someone comes up with your same invention but doesn't even know that you have a patent, you can still sue for infringement. So it provides a protection that has absolutely no, where the knowledge of the infringer is absolutely irrelevant. Okay? So trade secrets, we're going to talk about those pros and cons, but I wanted to give Alessandra a chance to talk about what the regime of trade secret protection is in Europe at the moment.
So, trade secrets, I would start from what's happening in Italy, because actually it's what's happening in Europe. Italian legislation on trade secrets is indeed very recent. It was introduced in 2018, and it comes from a European directive on unknown, undisclosed know-how and business information that is dated 2016. According to the regulation relating to trade secrets, actually trade secrets are protected when 3 different requirements are met. Information has to be confidential. What does it mean? It means that the information in its whole or in its elements, it is not generally known or easily accessible to the expert of the sector. Then the value of confidential information has to depend on their confidentiality. So trade secret information are valuable in as much as they keep their confidentiality, they are kept confidential. And then it is necessary that the person owing this information maintain and keep measures to protect the confidentiality of this information in an adequate manner. What does it mean? It means that from a practical point of view, companies has to adopt adequate measures in order to not only maintain this information confidential, but also to prove, to be able to prove that they were treating this information as confidential. If, for instance, in a future someone steals your information, you have to be in a position to prove that you made, that you took all possible measures to keep it confidential, such as easily password to protect your files, but mainly procedures. So internal procedures stating who is entitled to access to specific information and how they can access to specific information. One way could also be the one of keeping registry of who is accessing and when to specific information, such as accessing specific room where such information are contained. The owner of a trade secret is entitled to act against anyone who is disclosing, using, marketing such information, provided, however, this use is made with awareness. I mean, the third party infringing your trade secrets has to be aware, or should have been in a position of being aware, that this information was a trade secret, and a third party cannot be considered responsible of infringing your trade secret if he was able to develop autonomously the same sort of information without infringing yours. For instance, reverse engineering is allowed, and provided that, of course, it has been made autonomously without infringing any form of also contractual obligation. or without infringing your trade secret, getting information from employees or whatever. And another important thing about reverse engineering is that if reverse engineering of one of your invention is easily accessible, can be made quite easily, it does deprive, it means that your information is not a trade secret, because it does not satisfy the confidentiality requirement, and because the confidentiality requirement is that your information is not generally known or easily known or easily accessible by a person skilled in that sector. So if it's easily accessible, of course, it's not a trade secret, it's not a confidential information. Then another thing which is specific actually about Italy is that you have 5 years in order to act against someone that is infringing your trade secrets, which is different from the normal prescriptional period, statutory period, which is in Italy of 10 years. And finally, how can you use your trade secrets? Why are we speaking also of trade secrets? We were speaking about patents until a few seconds ago, actually, because you can also decide not to protect your invention through a patent. So after going through all the requirements that George told you, you can also arrive to the solution, to the final decision not to go through the registration of your invention. And so you have the opportunity of keeping your information confidential, treating it as a trade secret. How I treat it as a trade secret? As I told you, keeping adequate measures to keep it confidential. And protecting it against any use infringing your rights. There is also a way to exploit, from an economic point of view, your trade secrets, which is not registered as patent. That is to say, through agreement, usually of transfer of know-how, that are not actually regulated in Italy as in most of the other countries, actually, but they are mainly used by companies. Sometimes you do not know them because they just need to keep them confidential, of course. And so their content varies a lot depending on the form of the type of trade secrets that they regulate. And they usually have very strict confidentiality obligations for the purposes that I already explained. And usually confidentiality obligations in know-how agreement are without a term. So for an undefined term, that is to say that the person to whom you are explaining your confidential information is not allowed to speak about them for an undefined period without an end. So.
I'll say that with very minor differences, treatment of trade secrets in the United States is along the lines of what Alessandro just said about trade secrets in Italy and Europe. So what are the differences between patents and trade secrets? Well, with trade secrets, subject matter disclosure, yes?
Can we ask if there are any questions from the audience, or would you rather?
Oh, that's fine. No, we can ask any time. I mean, and I think as Chris said, if you guys have questions, please raise your hands and let us know. You know, we would rather be questions now. Yes, go ahead. Yeah, but as Alessandro said, the something you have to do is maintain the secrecy, right? And you also have to show that there's commercial value. Okay, so I mean, so if you have secrecy and commercial value, I think what you mean is, do you have to go to the government and get any sort of an approval? No, that's the point. So that's actually bullet point number 3 here. There's no government evaluation for trade secrets. So that's a difference between that and patents, which require the government to say, yes, you have an invention. Yes? It depends. I mean, you know, it's like everything. There are going to be different answers depending on the situation. So if you've decided this is not something we care about, right? We are just, this is not an invention we're going to use, but we want to keep other people from getting an exclusivity over it, yes, then you should put it out in the public domain, whether that's by a published patent application, whether it's by a journal article, whatever. I mean, and yeah, I mean, I guess if there's a situation where you just can't publish, then yes, file a patent application and ask for it to be published in 18 months, okay? But if you've decided there's value, I mean, then I think, you know, it's, you either patent it or you keep it as a trade secret. But again, it's hard to answer. It's hard to answer questions about a specific instance in generalities. I mean, that's just, you know, all I can say is these are options that you have. And at some point, your company has to make a business decision as to what it really cares about and what it doesn't. I'm sorry, I missed part of that question. Well, I mean, so if you've put your, if you've labeled something open hardware and you've made it public, right? So that becomes prior art. Someone comes up with an inventive advance over that. They're entitled to their own patent on this, but you can offer up what, you know, sort of a point and click license. It says, if you use our open hardware and come up with an invention, we get a license to it, or something along those lines. But, you know, you putting it out in the public domain doesn't affect the ability of other people to go out and patent improvements on what you've put out there, right? I think that's your, was that your question? Yeah. Okay. So again, with regard to the differences between trade secrets and patents, we talked about disclosure being mutually exclusive with trade secrecy, right? So if you file the patent application, it's published, there goes your trade secret protection. You can't do both. There's no specific term as long as you maintain the information in secret. So theoretically, trade secrets could last forever where patents expire. There's no government evaluation, as we talked about, so there is no filing fee associated with it. Generally speaking, you don't have to pay patent lawyers to, you know, help you figure out how to get trade secret protection. You either have it or you don't. And there's no protection against independent creation. So unlike patents where knowledge is irrelevant, if someone independently comes up with the same trade secret information that you have, in other words, they didn't come up with it through theft or some sort of ill-gotten gain from access to your trade secrets, they're entitled to use that. And your trade secret protection will not be effective against them. All right? So there are advantages and disadvantages to each. But the real question is, and we talked again about this yesterday, what is the practical effect of getting a patent? Because that's an important consideration. And the question is, given the nature of whatever the invention is a patent going to help you? And the example I always use is artificial intelligence, right? So you have a specific neural network that's been designed and you use that for, let's say, to discover new oncology solutions. So you've programmed your computer and it's taken over its own heuristic as far as identifying, say, combinations of drugs. It comes up with a novel and inventive oncology solution, combination therapy, right? So the machine has discovered this, all right? Now, you can say, well, I'm going to get a patent on the use of artificial intelligence using my neural network to discover oncology solutions, and that's great. But how do you ever show infringement by somebody else? How would you ever know? Because all you're ever going to see from these companies is perhaps the same oncology solution, but you don't know how they got there. You don't know whether they used artificial intelligence at all, let alone your neural network, and it's virtually impossible to figure that out. So getting a patent on the use of your AI platform to discover this combination of oncology products is probably a useless patent at the end of the day because there's no ability to enforce it. So in that circumstance, I would argue it's better to maintain the AI platform you've utilized as a trade secret, and then if you truly have a novel combination of oncology products, get a patent on that. And don't even worry about the AI aspect of it because that part is not going to help you. So I think that's a clear instance where if you have the option of maintaining it as a trade secret, you should do so. And not only that, but then you can take that same neural network that no one else knows about and discover all sorts of things. You're using that part of the invention over and over and over again without ever telling the public about it. And all the public ever knows are these novel combinations you're coming up with that you can get a patent on. And then you can keep other people from using those novel combinations, irrespective of how they came up with them. All right, so you've kind of identified what your goals are as a company. You've identified what inventions are important to you. You've identified where you want to get patent protection. The next step is to start filing. Prepare the patent applications and file them. So the first thing is to determine where to file. And this is a different conversation than where you will file ultimately, because you have to file somewhere first. And the question is where? So asking the audience, for those of you that have filed patent applications, how many have filed in the United Kingdom as a first instance? How many have filed in countries, other countries in Europe other than Cyprus as a first instance? How many have filed in Cyprus as a first instance? Okay, so I think this is a good time to talk about something, a resource that you all have that may be being overlooked. And I'm going to ask Alessandra to talk about what it is we've learned about registering patents in Cyprus and what the advantages of that are.
Yeah. Well, yesterday we had a very interesting visit at the registrar of companies here in Cyprus, actually, and specifically the office that is taking care also of the application of intellectual property rights. And what we learned, actually, and we found very interesting what we learned. Now, I will try to explain it, but as we are so lucky to have here Ms. Papaioannou from Senior Officer of the Register of Companies of Cyprus, I would ask her to correct me if I'm wrong while explaining to you what we learned. And well, actually, it looks like you have a very interesting opportunity here, because when you file a patent before your Cyprus office, actually the Cyprus office forward the application to the European Patent Office, and in a very limited time and for very limited cost, if I'm not wrong, 700 euros. And within 6 months approximately, if not before, you get from the European Patent Office not only the result of the prior search, but specifically specific recommendations on your application from the European Patent Office, discussing and treating also the requirements and the satisfaction of the requirements of your application. And we actually saw on a confidential basis an example of these recommendations, and actually they are quite detailed. And what we thought is that it could be a very interesting instrument for you, very cost effective and very fast, so very efficient generally, in order to get the recommendations, the comments directly from the European Patent Office before applying to the European Patent Office, so that you are in a position to decide whether to proceed with the application based on these recommendations, as well as to go further, applying then to the European Patent Office and going on with the protection of your invention. So actually, we now understand that none of you tried to first file your application in Cyprus, but we believe that actually it looks like to be at least an opportunity. Did I speak correctly? Did I report correctly what I learned?
Thank you. Maybe we should. Maybe we should add that the amount that you mentioned is the result of some return of fees.
Mm-hmm. Oh, yes.
€100 is filed with the first application, then 200, €500 are paid for the search report, and 75% of that is returned to the applicant once the report is prepared and sent back to us. And another small detail is that this is part of a cooperation agreement that we have with the European Patent Office, since we are not in a position to effect the search report ourselves.
Yeah, indeed.
And we are at your disposal for any more information that you may need.
Yeah, so there is also this 75% of cost back that you receive back then, so which is interesting, and that's it.
So I just wanted to highlight one aspect of this, right? So on day one, you file your Cyprus application. Within 6 months, you get your European Patent Office report, basically saying, yeah, you've got something that looks inventive here, or no, you don't, with all the prior art cited. And then, I think it's by statute, the Cyprus registrar will determine to issue a patent or not within 16 months. That is incredibly fast. In the United States, you can wait years, and I do mean years, for a patent. I've seen patents that have been pending in the Patent Office for a decade. So the fact that that is basically a mandate gives you an enormous advantage where you truly have a patentable invention. It comes out of the patent or the registrar's office very, very quickly. So, I mean, I would recommend at least considering filing in Cyprus first because, one, you're here, two, it's relatively inexpensive, and three, it's very fast. But you can also avail yourself of all those other national filings you want to do down the road using the patent here as a priority. So you get all the advantages of your international filing scheme basically by starting it all off here. So, but wherever you decide to file, whether it's the United Kingdom, whether it's the United States, whether it's Cyprus, whether it's Germany, wherever it is, I mean, you have to file somewhere. And one option you have, which is considered a national stage filing, even though it involves a multiplicity of jurisdictions, is the European Patent Office. And I know Alessandra talked about that yesterday, but I think it's worth going over again what that actually means.
Sorry for the ones who were here yesterday if I'm repeating something, but as we were saying yesterday, actually, currently you have two different possibilities to file a patent in Europe and get protection in Europe. to file different national patents before the different national offices, patent offices, or to get a European patent. Let's call it a classical European patent, which turns to be a bundle of several patents. At the end, you will be in a position to decide, if you decide to apply for a European classical bundle of patents, you will be in a position to select which European countries you are interested into based on your decision, your business decision, based on your future plans of marketing your invention and whatever. And it's also interesting in how you have to take into account, because you don't have to make confusion between the European member states and the countries that adhered to the European Patent Convention, which are more and which are not necessarily European member states, such as Switzerland and Norway. They are not European member states, but they are part of the European Patent Convention. And you can decide in which countries you are interested. This means that you will have to pay fees for registration and renewal just in those countries, specific countries. But, of course, if you want to defend your rights related to these patents, you have to go before the national courts. There is a big reform going on in Europe, as I told you yesterday, that is to say the European unitary patent, that includes also a unitary patent court, European court, that will provide with the possibility of being the owner of just one patent, so just one title, being valid in all the European member states, in this case, that accepted to be part of the European Patent Court agreement. So in this case, the unified European patent will be available just for European member states and exclusively for those European member states that accepted of being part of it. For the time being, we know that Cyprus has not ratified yet the European Patent Court Agreement, so we will see in the future what they will decide, what your country will decide to do, actually. But you know that there is this possibility in Europe going on. In this case, you will be the owner of a patent, a unique patent, in all the members of that adhered to the European Unified Patent Court, actually. And what are the advantages of this? For sure, a decrease of litigation costs, because in case you need to defend your right, you will need to go just before one court and not several national courts. Then you will have also potentially at least an economic benefit, because the renewal fee for the European patent has been calculated as an average of 4 renewal fees of a different national country. That is to say that if you will decide to if you are interested in less than 4 countries in Europe, it's more efficient for you to file a classical European patent, because otherwise the unified patent will cost more and it will be effective in countries where you are not interested into. Then another advantage will be the fact that while now the single and national courts apply European principles, may apply European principles in a different way, the fact to have one unified court will reduce the risk of differences of interpretation among the European territory and the application of the European patent. Consider, however, that the unitary patent court will be effective after a transitional period of at least 7 years. It will be applied also to the classical European patent. So for a period of 7 years, nothing changes for European classical patents, And even the owner of the new European patents will be in a position to decide to opt out the unitary patent code. That is to say, I am the owner of a unique European patent, but I prefer, for the transitional period, not to adhere to the unified patent code and to decide to go to the single national codes. Because, for instance, I know how the national codes decide, rule, and I want to wait and see how the unified patent code will establish its case law in order prior to go to the unified patent code. Yeah, I think this is a summary of what we discussed yesterday.
I think it is important to note just generally that what we're giving you is an overview, right? I mean, so there are details that we are not going into because we just don't have time. And it is important whenever you're looking to file patent applications to make sure you're consulting with people who can actually fill in the blanks that we're leaving. This really is to give you something to think about going forward rather than constituting the kind of specific legal advice you might get when you sit down with a patent lawyer and explore what your options are and what you should be doing vis-a-vis a particular invention. So the world, yes, sorry. Yes, Maria.
Anybody who is a member of the Cyprus Bar and they are registered in Cyprus, a practicing advocate can file a patent application. We don't have a separate profession of patent attorneys. This is the Cyprus law. Any lawyer can file a patent application. Any lawyer can find a patent application on behalf of their clients.
So there's a solution to this, right? And it's not unique to here. I mean, we do this all the time with attorneys we work with. So, for example, Marilia is a general lawyer here in Cyprus, and she has the ability to partner with patent lawyers in other countries who can prepare the technical disclosures of the patents, because the important thing in these circumstances is really to make sure that the technology is accurate. And by way of example, in our firm, we will oftentimes prepare patent applications in the United States to send to our German lawyers to file in the European Patent Office. Their job is simply to make sure that the document is in order, as opposed to vetting the technology or the technological arguments or the disclosure or whatever it is. That's our responsibility. I mean, the patent law, as you probably have gleaned over the last day or so, is fairly harmonized. So the requirements are fairly much the same. So the prior art is the prior art, doesn't matter what country you're in, and your invention is novel and inventive or not, depending on what country you're in. Your specification enables somebody of ordinary skill in the art to practice your invention or not, depending on what country you're in. So really, the idea here is that lawyers in Cyprus have at their disposal patent lawyers from around the world that can assist in the preparation of these things. And that really, just anecdotally, has worked over and over and over again in my practice and the practice of just about everybody I know. I mean, keeping in mind that traditionally, patent boutique firms, it was only recently that patent law firms around the world became part of larger general practice firms. Before that, you would have firms that basically were only in the United States, were only in Great Britain, were only in France, and they would work with foreign associates. The foreign associates did not reinvent the wheel. The patent lawyers in Paris or London or Washington or wherever they were would prepare the patent applications, get them translated, and send them to their foreign associates in Latvia or Romania or wherever. And all that the foreign associates would do would be to make sure that basically the legal requirements, the formal requirements of the application have been met. And that is truly something that any lawyer can do. Yes?
What Maria is trying to touch on here is that basically this is the vast majority of the cases for Cyprus. This is the mode for cooperation for preparing the patent and the claims. And this could be the reason why the filings are so low in Cyprus. It could potentially be one of the reasons why.
Because of the cooperation issue?
Because this is the type of relationship that lawyers have to use in order to get the patent written.
I don't think there's, tell me, is there an attitude against cooperating with lawyers overseas?
No.
True. Mm-hmm. And that knows the technology, basically.
I believe that the problem with the lawyers in Cyprus is how to settle and how to put things together in the patent. They don't know about strategy, how to do things in writing.
That's what
they don't know the wording, how to use the correct words. Sometimes this is crucial. All the times it's crucial.
But that's what the U.S. That's what we do. So again, we do this all the time.
Yeah.
For our U.S. clients for their filings overseas. We draft the patents. We are the ones that implement the strategy. We are the ones that select the words.
That's what we say. In Cyprus, there is nobody to do this.
No. But my point is, someone in the United States prepares the application, sends it to Cyprus, where it's already done, and the lawyer in Cyprus says, okay, are the inventor names on there? Are the names spelled correctly? Do they have claims in there? And they don't have to go back and say, okay, well, is the technical strategy correct? Did they use the right words? That's already been done. The only question is, has it been translated correctly? And that is not a technical distinction. That's basically just make sure you hire the right translator, and when the word is oligonucleotide, which I think is probably the same thing in Greek, that's
Correct.
what's in there.
Why do we have to go first to the United States and then come to Cyprus to do this?
Please. Yes, please.
So basically, I think what most people have a concern vis-a-vis your trademark. Can you hear me? I think I do. We don't have lawyers with the technical background, scientific background. We don't have that as a concept. We just have practicing lawyers. So what most people, I think, in this area are concerned about is that they don't know who to go to, who will then take them somewhere else. So what I would say is that people who are interested in patenting things have to go to a law firm. That law firm will have a network abroad.
Correct.
Around the world. Mostly I work with people in the US, which is true. So what usually happens is that you go there, they come to what they're thinking of doing. The claim goes to the patent attorney, who usually has a technical background. They will help you draft the claim. And through their network or your own network, that will be disseminated to all the countries that need to be informed.
Yes.
So for example, if they need it in Cyprus, it will be translated into Greek prior, to Italy, then in Italian, etc. So I think it's more about being aware of the procedure rather than there's no way for it to
Correct.
It is done because people that are heavy technical in their company.
You said it much better than I did. I think that's absolutely right.
Can I just add something?
Yeah, sure.
The question.
Excuse me, we can't hear it.
I am trying to.
Excuse me. Can we just hear
On
the
the
comment?
question that was put by the gentleman, what is the reason why we don't have so many applications? The main reason, actually, if you want my own personal opinion, is cost. the people who want to apply for a patent, either in Cyprus, only in Cyprus, or through the European system or the international system, are very much aware of the cost. It's not just the cost of the filing of the application, it's the cost of what you have just mentioned, the preparation of the patent documents, what is called the drafting of the patent. You need specialized people to do this in order for the people who are going to examine the patent to be able to read it, understanding, and be able to see whether what you are describing is patentable or not. So that is the cost that is most threatening to most applicants.
And that's true.
But statistics show, research shows that once an invention is patented and once a patent is issued, it is worth all the money that was paid, because we have to keep in mind, and I'm sure it was mentioned maybe yesterday, but I wasn't here, a patent is a piece of property. And it's a very valuable piece of property that is sold, it is rented, you can hire it, invented commas. So you should keep in mind that the money you pay for the drafting of the patent to the people who have the, all these networks that was just described by our US friends, it's worth every penny of it. It is worth every penny on it because of the final price and because of the final value of what you get by having your invention patented. Thank you.
I agree with all of that, but I want to add one thing. That cost is the same effectively no matter where you file first. So whatever the expense is for preparing a patent application, whether it's England, Canada, the United States, Cyprus, China, it's going to be the same. You still have to expend that cost. So this cost issue really is a decision criterion as to whether to file a patent application at all, as opposed to where to file it. Because once you've made the decision to file it, you're incurring that expense. It does not matter where you file first. And you pay one. That's true. That's right. So yeah. So basically, if it's $5,000 or $7,000 to prepare a patent application, it's going to be $5,000 or $7,000 no matter where you file. Yes, sorry, go ahead.
Just to say again, I don't think it's about the cost.
I don't either.
It's not the same with the time. Basically, people don't know where to go. It's
Yeah.
not about the cost.
I think you're right. I think as far as the decision where to file, I agree with you. Whether to file, cost is obviously a concern. But I think you're absolutely right. It's just a matter of letting people know that it's not just a matter of what do attorneys in Cyprus know or not know, who they know and what kind of a network can they bring to the table to help anyone file a patent application here that will be competent, defensible, and actually commercially valuable at the end of the day. And I do believe there's a real potential for that here. I mean, you obviously have competent lawyers. I mean, there's no question about that. And one part of being a competent lawyer is knowing what you don't know. I would never take on a criminal case in my life because I know I would be dangerous doing it. And I think that's true of most lawyers that are worth their salt. So the ones that actually, are interested in doing this kind of work will know I've got to affiliate myself with someone who actually has filed a patent before and that has the technical expertise to understand what the invention is all about. Yes.
Sorry. Please.
How would you recommend, what do you recommend for someone on how to identify the right patent lawyer for his invention? Maybe some firms specialize in some particular area or an industry, maybe?
So firms are not shy about posting what they do. You can actually get on a website, like our website. Every single one of our attorneys has a biographical sheet, and you can see everything they do and what degrees they hold. And there's even a subsection of our website that talks about practice groups in general. So you'll learn about, for example, in our case, how many PhDs we have. I've told a couple institutions now this. I mean, in Chicago alone, we have 2 PhDs in the life sciences industry that are also lawyers. They are much smarter than I am. And I would never try to take on a case without getting input from one of them. So, I mean, and every law firm is the same. You can go to each law firm page and find out what they do and what their expertise is.
Just look for intellectual property and a lawyer that is active in the intellectual property field may be able to help you.
But in the first instance, if you have a local lawyer you work with, I think one of the things I would ask is, have you worked with patent law firms before? Is there anyone you like? Is there anyone that you would work with? That, I think, is a key question. Again, it's not unique to Cyprus. This happens around the world.
Yeah. Also in Italy, I mean, we are IP lawyers, but we are not allowed to be patent attorney. I mean, and that's the same situation in many other European countries. But this doesn't stop the possibility of local companies to address to local lawyers, and who will go to professionals having the technical expertise, and for sure you will have time, given also the great technological development that you are going through in this country, that is evident, and so the system will organize, and you will probably develop patent agency within the country or whatever. In the meantime, there are international networks you can rely with. So this is something that we do on an ordinary basis, on a daily basis. So that's normal. Yeah. Sure.
I just wanted to perhaps to answer your question. I wanted to ask before as well. Many people come up with questions through lawyers that have nothing to do with lawyers can't answer, and I think that's the difficulty that we usually get. What countries should I file in? That's not an answer your lawyer can give you, and that is potentially not an answer that your patent lawyer can give you. So that is heavily dependent also upon your business plan and you understand the product that you're trying to, the product you're trying to sell, how you're going to use it, if it's going to be a trade secret or not. So it is heavily business driven, not just from a legal perspective.
Well,
I just wanted to add that.
It is, but I think with the right set of questions at the beginning, I mean, one of the things that we would typically do with any client who's looking for patent protection, we would ask them, where do you think your market's going to be? Who are your competitors?
But ideally, if you're willing to spend so much time on something, those are questions you should have already thought of.
Yeah, but
yes, true.
We know our work. It's like this.
500,000 developers know this already. It's not a question that the lawyer is
I know. Look, like you're.
That's one point. You would also need to educate your
Yeah, indeed.
what is a patent, what is a trade secret.
Indeed.
Sure, they may not have thought about that.
But again, the lawyer won't know the product.
So-
You know what you're selling.
So,
You need to be able to
yeah,
decide.
true, but
As a general point, I'm not, it's not a matter of us discussing here, it's just from the point of my perspective, I think it's something that would be good for people who are interested in basic things to think of.
well, I think that's why everybody's here. That's the good news. I think they're here to learn about these very issues.
The concern isn't so much about the lawyer, that's what I'm trying
I know.
And I hear that a lot from friends that are in startups that I can't find a lawyer to help me. Well, there's so much a lawyer can help you do if they're not of a technology.
Yeah, I think that we all need the right attitude. That is to say, companies rely on local lawyers and lawyers trying to help companies understanding their needs and trying to educate them and explaining that there is something that we can't do, and helping them understanding what our role is and what we need from them. So probably there is a cooperation that is we need to bring on.
So I think we're going to take a break. Is that right? Oh, sorry. Yes.
As a follow-up question to my original question, actually, how you select the answer you gave assumes that there is definitely a lot of information out there, but the answer you gave assumes that the consumer, some company or some startup, is well
Sure. I mean, no, there are awards that firms get, but I mean, basically finding this information, right? You're talking about the Internet of Things out there and trying to sift through all of that to come up with the criteria that what I guess you're saying is, you know, you're shooting at a target in the dark that may or may not even be there. So the point is, I think what the startup should know, to follow up on the lawyer's point back there, I think what the startup should at least know is what their technological sweet spot is, right? They clearly aren't going to go hire a patent firm whose expertise is mechanical engineering if they're in the life sciences business. So you could certainly weed down the universe from here to here pretty quickly. And then after that, you know, you can start looking at some more specific things. So, for example, one of the PhDs I mentioned is in neuroscience, okay, in our office in Chicago. So if you're investigating neurodegenerative diseases, I'm guessing that's somebody you'd want to talk to. Now, is she the only neuroscience person out there? No. But, I mean, you only need one. And, I mean, I would argue that if you're spending time trying to find the best, that's a waste of time. So.
Just before we all go, Salo, can you come here to introduce yourself already? We're very lucky to have Salo with us today. Okay then. Okay.
All right, so welcome back, everybody. I think in the name of time, we are going to move on to the fourth and final segment, which is patent ownership, assignment, and licensing. So this is the section where we discuss what you do with a patent once you get it. And a point to reiterate in this first slide that we have up here is that a patent is in fact property and has all the characteristics of property, which means that it has value, it can be acquired, transferred, rented, or abandoned. So it's like any other type of property that you can think of, but it is intangible. In other words, you can't see it, you can't hold it. I mean, the piece of paper on which a patent is printed is not the patent itself. It's just a copy of whatever the intellectual property right is that's embodied therein. So when a patent application is filed, assuming the inventors file in their own name, the assignment or the application is owned by the inventors. That's the legal presumption pretty much everywhere. The inventors are the original owners of a patent application. And unless and until they transfer those rights, those ownership rights to another party, they continue to be the owners. But, as I said before, a patent is property and can be freely transferred by the inventors to others, and often are. It's very unusual to find a patent that remains owned by the inventor or inventors once it is issued. So where you have an employer-employee relationship and the employee is engaged in inventive research, the transfer of ownership may be required by the employment contract, and that again is pretty much the norm. It is unusual where an employee engaged in inventive research on behalf of an employer is not obligated to the employer to transfer ownership. Some universities that I'm aware of actually allow for the professor employees to keep the inventions if they want, and that's basically the default. But the vast majority of employers, including universities, oblige their employees to transfer inventive work to the universities or employers. So where there isn't an employment contract, in other words, there is no contractual obligation per se, then in that circumstance for sure, there has to be an assignment document from the employee to the employer saying, I, employee, transfer to you as owner, the employer, my invention. Okay? And if you're not familiar with what an assignment document is, it's basically a unilateral document executed by the person transferring the property from him or herself to the employer. All right? Where there is an employment contract, so basically when an employee takes employment with an employer, he or she signs a contract saying, here are the terms and conditions of my employment. If there's a provision in there that talks about what happens to intellectual property, right, then that creates a contractual relationship mandating that the employee transfer any intellectual property to the employer. A question arises, though, as to whether a separate assignment is still required even when there's an employment contract mandating transfer. And it's important when looking at the language of the employment contract to see if the employment contract itself is the transfer document or if a separate assignment is required. So I apologize because this is in English and there may be some nuance to the language, but hereby assigns is language that oftentimes appears in an employment contract. And what that says is, as of the moment I sign this contract, I am assigning my rights in my intellectual property, whatever it ends up being, to my employer. So it's an assignment as of the time that the employment contract is signed. If the contract, on the other hand, says, I will assign my intellectual property because it's in the future, the employment contract does not represent the transfer document. In other words, all that the employee is agreeing to do is in the future. assign his or her rights and intellectual property to the employer. So it's not being done as of the time the employment contract is signed. And in that circumstance, there would have to be a separate document, an assignment document, executed by the employee when the assignment occurs. So if the employee invents something, he sits down, writes an assignment document, and says, I am assigning my rights in this invention to my employer. In any event, if the employee, for whatever reason, fails to assign or files an application in his or her own name and doesn't transfer to the owner, or the employer rather, the employer has a right to sue the employee for breach of contract and require that the assignment, the appropriate assignment, is executed. So, practically speaking, it is my opinion that whether the contract language says hereby assigns or will assign, there really should be a separate assignment agreement in any event. And the reason for that is whether you're talking about the United States or Europe or most places around the world, assignments have to be recorded with the appropriate patent office. So the patent office won't recognize the transfer of ownership unless you file the assignment with it. And obviously an employment contract won't qualify for that because it's not identifying any particular intellectual property. So there has to be an assignment that says, I, employee, assign my rights in invention X to my employer. And that gets filed with the patent office, wherever country you're in, and that affects an assignment that's recognized by that patent office. I will say that with regard to Europe, if you file the assignment in the European Patent Office in Munich, that is effective to basically register the assignment in every single country that you've elected to have national stage patent protection in. So if you filed in the EPO and the European patent issues, and then you seek national stage protection in Germany and France and Italy and Denmark, once the patent is assigned, if you file in your assignment in Munich with the EPO, that affects a transfer as to all 4 of those countries automatically. You don't have to then go and file in each individual country's patent office. So, as is often the case, and I think what you will find if you are in the academic research environment, patents are seldom invented by one person. It's generally the result of collaboration between a multiplicity of inventors. So the question is, what does that mean as far as ownership is concerned? If you have 4 inventors on a patent, how is the ownership divvied up, if you will? Well, I want to go to the 3rd bullet point. In most nations, individual owners have an undivided interest in a co-owned patent. That means they basically have their own discrete share of the whole of the patent. They own it in its entirety, every single one of them, individually. So they have certain rights as owners, independent of the rights of all the other owners. Okay? So what that means from the standpoint of transfer of ownership is if you have 4 inventors who all work at the same institution, in order to transfer ownership of the entire patent to the institution, all 4 inventors have to effect an assignment to the institution. If only 3 do, well, the institution is an owner of the patent, but then so is that 4th inventor. He or she remains an owner and can do whatever an owner can do, irrespective of the fact that the institution is also an owner. So generally speaking, what does it mean to be an undivided interest? Well, at least in the United States and most other countries around the world, by the way, I should mention that ownership rights are not determined by patent law. Ownership rights by European patent law or the general patent principles. Basically, you look to the national law of the country that you're talking about to figure out what the ownership rights are in a patent. So if we're talking about a US patent, you look at US law. If we're talking about the ownership of an Italian patent, you look at Italian law. So you have to look at the national law of the country in question. So if you get a European patent and that leads to national stage patent protection in 6 or 7 countries, you have to look at each of those countries' national laws to determine what the ownership rights are in the national stage patent there. And it may be very different depending on what country you're talking about, as we'll hear in a moment about Italy. So, in any event, in the United States and in many other countries, an undivided interest means that each can practice the patent. So they have the right to practice the patent to the extent they can do so without the need to satisfy other limitations, like, for example, drug approval. Each can assign or license the patent. So if I am an inventor and I want to assign to this party over here, my co-inventor wants to assign to that party over there, each is free to do so. They can also license the patent, each one. So it may very well be that one inventor enters into a license agreement with one company, the other inventor enters into a license agreement with another company, and each of those licensees has the right to practice the patent. I mean, they have gotten a valid license from an owner of an undivided interest in the patent. So, as you can probably imagine, issues of co-ownership really matter when it comes to figuring out how and by whom a patent can be commercialized. The one kind of quirk about undivided ownership interest, at least in the United States, is if you want to sue for infringement, in other words, you found somebody that's infringing your patent and there are multiple owners, each owner has to participate in the infringement suit. A single owner where there are multiple owners cannot proceed on its own, which again can provide for, there's a situation in the United States where a patent was owned by one university and co-owned by a research lab. The research lab wanted nothing to do with the infringement litigation, and so the university had to figure out how best to handle this issue, and they basically ended up losing their right to sue for a very valuable patent and an enormous infringement because the co-owner didn't want to join in the infringement action. Now, so as you can see, the issue of co-ownership can set up quite a number of problems. So as with anything, the way to address these kinds of prospective issues is by contract at the very beginning. So where there is going to be co-ownership, for example, where inventors from 2 different institutions collaborate in the creation of an invention, with each institution having assignment rights from its respective inventors, you end up with 2 owners, the 2 institutions in question. So typically speaking, these institutions execute something called an interinstitutional agreement. And those agreements deal with all of these sticky issues, right? What can the 2 owners do or not do with regard to the patent? How is it going to be enforced? Who is going to pay to have continued prosecution and maintenance of these patents? So all of the issues that really need to be sorted out when you have multiple owners should be in one of these contracts. Now, what I said before about checking with the national laws regarding what co-owners are entitled to do, anytime there's a relationship between parties that is dictated by contract, that trumps national law on ownership. So the parties can create their own private law between them through a contract. So even if US law says that co-owners have an undivided interest in the patents and can do anything they want with them, by contract, the contract can specify we, party A, have the right to figure out what we're going to do with this patent, and you, party B, basically have to go along with it. Okay? So I would like Alessandra now to talk about the issue of co-ownership in Italy, which I think will illustrate why it's important to know what co-ownership rights look like on a national basis.
Yeah, this is just to stress the fact that it is very important to check what the laws provide in the countries where you are granting protection, because Italy, as we will see, provides different provisions of law respect to the US, for instance, and other countries. Italy has indeed a specific regulations for the so-called group invention. They are called like this in the Intellectual Property Code in Italy. That is to say, an invention that are realized by a group of persons who work together. This is the definition that is provided by Italian law. And the group invention actually is something that deals exclusively with the co-inventors. That is to say, you can't be a co-inventor of a group invention if you haven't participated to the inventive process. So if you have helped support the creation of an invention just from an execution point of view, you can't be considered a co-inventor. Okay, you have to have contributed to the inventive process for being it. And according to Italian law, actually, the filing of a patent, so of an application, of a patent application, as well as the payment fees, the payment of the renewal fees, can be applied, can be made, can be carried out by each of the co-inventor, but on behalf of the others. That is to say that there has to be an agreement among the parties, and in the absence of this agreement, we can expect that if one of the co-inventors act in one of these activities in a way that is against the interest or the will of the other co-inventors could defend their position against the co-inventor who acted autonomously. But there are other type of activities such as the implementation of rights related to the patent or the grant of a license on the patent that has to be decided by the majority of the co-inventors, because actually the Italian property code doesn't state anything on this activity, but according to Italian case law, we have to apply the civil code principles on joint ownership, and the Italian principles on joint ownership provides that it has to be the majority to decide these sort of activities. And then again, the presumption under Italian law about the measure of the participation to the co-ownership is that all quotes are equal. That is to say that all co-inventors are equally participating to the invention. And again, what's our suggestion? Our suggestion is to have an agreement in place among the co-inventors in order to regulate the way you want the patent from the application to any sort of further activities to be regulated prior among the parties in order to avoid any sort of activity, non-desirable activities by the other parties.
So I briefly mentioned interinstitutional agreements, and I just wanted to go into some of the normal provisions you would find in one of those. So first of all, it's just an agreement between two or more institutions that are engaged in collaborative research regarding how intellectual property that results from the collaboration is going to be handled. So it may be an umbrella agreement, which means that anything that comes out of this collaboration or any collaboration we have will be handled by this agreement. It may also be limited to specific projects. I mean, both are perfectly fine, and it may very well be that a general agreement is satisfactory because basically you don't anticipate the situation to change very much. On the other hand, it may be that different projects warrant very different treatment. So, for example, it may be the case that researchers from one institution are taking the lead on one project and researchers from another institution are taking the lead on another, and the way that those relationships are going to be handled may very well look different. So the typical provisions, again, it's a contract. It's basically a contractual agreement between the parties and will contain contractual provisions. And the typical ones you see in these kinds of agreements include The responsibility for patent procurement. Once there's an invention, who is going to take the lead on dealing with whatever patent office is going to be evaluating your patent application? Really, both parties should not be working at cross purposes. There should be one party out there that's responsible. Hiring patent counsel, making sure the patent specification says what it's supposed to, and that patent protection is filed for wherever it matters. Ability to license third parties. So the agreement may very well specify, and probably should, who makes decisions on how to license, who to license, what to license. I mean, just basically any licensing decision that any patentee would make should vest in one party or the other by virtue of these agreements. Responsibility for enforcement. In the event that infringement is found, how is that going to be handled? Who is going to take the lead on it? And where there are co-owners, as I mentioned, you need the participation of both, in the United States anyway, so the agreement should provide that both co-owners, in the event that infringement is discovered, will cooperate with the other to the extent necessary to ensure adequate enforcement. Sharing of any resulting revenues. Let's say that the co-owned patent generates revenues either in the form of a royalty, some sort of license fee, or an infringement award. How are those profits, how are those revenues going to be shared? It may specify that it's based upon the relative ownership interest of each. It may be whoever takes the lead gets the majority share, but that should be something that's dealt with beforehand. And then the transfer of ownership of one party to the other. So in other words, if one party feels like basically buying the other party out, what are the circumstances under which that can happen? And it may even specify a transfer price right off the bat, so there's no bickering down the road as to what the patent's actually worth. These are just some of the provisions. Obviously, we can imagine many, many more as far as what should go into an interinstitutional agreement. So licensing. So first of all, what is a license? So we can understand what the transfer of ownership is. I give you something and it becomes yours. But a license isn't that. I'm not giving you the patent. What I'm basically doing is letting you use it. So a patent is a transfer less than all of the ownership rights in the subject patent. It's like renting an apartment. If I rent you an apartment, I'm not giving it to you, I'm letting you use it. And there are certain rights that come along with that. Ownership is not one of them. A patent license is the same thing. I'm letting you use the patent, which confers upon you certain rights. I can't sue you for infringement while you have the license. But it is not a transfer of ownership. You are not the owner, you are just the licensee. And the form of document, I've seen this in the United States quite a bit. I've seen things that say that they are an assignment. It says it right at the top, assignment. But then when you read the document, it in essence transfers less than all of the ownership rights to the transferee. Okay? So the putative assignor holds back certain rights for itself. Well, again, that's not a transfer of ownership. I can't sell you my house, but then say I've got the right to come into it anytime I want to. That's not a transfer of ownership at that point. I mean, I'm reserving rights in my property, even though I'm purporting to transfer ownership to you. So it's the same thing with a patent. So whatever you call it, whether it's an assignment, a gift, whatever, if you don't transfer all of the ownership rights, it's not a transfer of ownership. So there's the most common example of this is a quote-unquote assignment where the assignor transfers all rights except the right to pursue infringement of others. So I say, I am transferring ownership of my patent to you, but if I find there are infringers out there, I still get to go sue them. That's not transfer of ownership. It may be a transfer of something, but ownership is not one of those things. And a patent license, so what it basically does, at its very essence, is it gives the licensee freedom from infringement, a freedom from infringement suit by the licensor. I am letting you use my invention, and I can't sue you for infringement. That is the very essence of a license. Now, Does it prevent other people from suing you if they have their own patents on the technology? No. All it does is provides you with the right to use the patent without worrying about being sued by me for patent infringement. Now, there was a question yesterday about mandatory licensing. Let me first say that there is no such thing in the United States. A patent owner has the right to exclude others, full stop. And that is independent of whether the patentee ever practices the patent or not. So I can have a very valuable drug patent in the United States, and I can put it on a shelf and let it gather dust. If someone else comes out with a drug, I can sue them and either get damages for that, or more importantly, I can get an injunction preventing them from future infringement. And they can't argue, well, wait a minute, this is a life-saving drug. I have a right to sell this. No, you don't. You're infringing the patent. That's it. That, however, is the minority rule around the world. And I'm going to let Alessandra talk about the concept of mandatory licensing.
Yes, indeed. That's another example of why you need to check the regulation of the various countries in which you are looking for protection for your invention, because actually in Italy we have a completely different regulation relating to compulsory licensing or mandatory licensing. And specifically we have two types of mandatory licensing. The first one is when applies when the patent owner does not implement or implement in an insufficient way the invention. And the second one is when the implementation of a patented invention is not possible without prejudice to the rights of a prior patent. So let's go through these two options. The first one is that you can have a compulsory licensing when an invention is not duly implemented or implemented in an insufficient way. According to our regulation, which is most important between the interest of the owner of a patent and the interest of the country, is the interest of the community of the country. In this way, according to Italian legislation, to Italian law, if an invention is not implemented or sufficiently implemented for 3 consecutive years, if there is someone that offers himself or herself or itself, if a company, to implement this invention, it will obtain a mandatory license. That is to say that the owner of the invention will be obligated to provide a license to this subject. And actually it will apply autonomously, so there is not any formal need, just the law provides that this license will be effective. In order to recognize the prevailing interest of the country in this. And we have to note that the mandatory license does not apply if the lack of implementation doesn't depend on the will of the owner. So what is relevant is that the owner does not intend to use the invention. That's relevant. If the lack of implementation of the invention depends on objective reasons that do not depend from the will of the owner, the mandatory license does not apply. For instance, if there are technical reasons for which the implementation of the invention takes a longer time than 3 years, it is considered a justified cause for not applying the mandatory license. So there is a reason why you are not implementing your invention. That is to say that there are technical reasons for which you need more time to implement it. So that's okay. Another reason is the lack of demand on the world market. So there is a word a worse situation according to which there is a lack of demand on the market of specific products related to this invention or services related to this invention. And another reason can be the existence of a counterfeiting that makes non-economic to use a specific invention. So there is a counterfeiting going on, having in object your invention, and to fight against this counterfeiting is too expensive, and it requires tremendous economic efforts, so you are justified to renounce to implement this invention. But you can't justify the lack of implementation because of your specific lack of financial resources, because of a specific lack of local demand in the market, because you went bankrupt, and for specific reasons. These are not reasons that are considered sufficient to avoid the compulsory licensing. The second type of mandatory licensing is when the implementation of a patented invention is not possible without prejudice to the right of a prior invention. That is to say, you have an invention that has been correctly and legitimately patented, so it doesn't infringe a prior patent, but the implementation of your invention, of your patented invention, actually provides prejudice, provides damages to a prior invention without infringing it. That's the condition. In this case, if you can provide that your invention that has been filed as a second invention temporarily provides a great economic advantage to the country, you can obtain a mandatory license on the first invention. So you will be able to implement your invention thanks to a compulsory license on the prior invention, in order to balance the interest of the owner of the inventions. Also, the owner of the first invention will be entitled to get a license on the second invention. So this is the situation in Italy.
So lastly, oh yes, go ahead.
In some countries, in Spain, for instance, we have the concept of usucapio. If you have, is that applied to? Do you know what I'm talking about?
I'm sorry, I missed the word in Spanish.
We say Latin name is usucapio. When you have a property, and you lend the property to somebody else, and the person keeps using the property. You don't complain about the use, and after 10 years, at least in Spain, if I have a ground, and a cow is in my ground, the guy will get the property. Do you have this concept in patenting?
So we have something similar in the United States. It's called taking, and I mean, but that's for different reasons. But the idea is it's a way for the government to take property, irrespective of the intent of the owner. But the bottom line is, as with any property, it can be abandoned. You can lose it. I mean, you can forfeit it. Anything that you can do with any other kind of property, or that can happen to any other kind of property, can happen to a patent. So yes, I mean, so for example, we have a procedure in the United States. It's called inter partes review. It's a post-grant review where, I think I mentioned this yesterday, where a party can challenge the validity of an issued patent. And if in fact the party proves its case, the patent office revokes your patent. So in that circumstance, you've lost your property right. I mean, again, it's not entirely apples to apples, but there are mechanisms by which you can lose your property right, as is the case with, I mean, if I own a house, I owe the government taxes. I don't pay my taxes, they can take my house, right? I mean, so there are ways to lose property. So the last thing we want to talk about today is licensing provisions, or at least the typical ones that you would see. First of all, it has to identify what's being licensed. Typically, it's whatever the patent is or patent application, and then the notion that anything that is filed off of that patent application, so things called continuations, for example, future applications off of your priority, foreign counterparts, all of those things would be under the umbrella, typically, of what is licensed. Exclusive versus non-exclusive, just like the name says, if I give someone an exclusive license, that means they're the only person that can practice this patent under license. I can't go license somebody else. If it's a non-exclusive license, that means I can license as many people as I want. Typically, exclusive licenses engender higher royalty rates or payments, by the way, because the rights are more valuable. The license term, how long is the license going to be in effect? Typically, it's for the length of however many patents are being licensed. And the language typically is until the last to expire of the licensed patents. It may be shorter for whatever reason. That typically isn't the case. Field of use. So basically, I can license you to use my patents in any way you want. So in other words, if you come up with a new way of using my invention in 10 different ways, you have a license to each of those ways, right? It could also be a field of use license. So for example, if I have a small molecule patent, I could limit the field to cancer, right? Or particular kinds of colorectal cancer, for example. And you have a license to use that small molecule to treat colorectal cancer. That's it, right? If you use it for any other purpose, I can sue you for patent infringement. And more importantly, as the licensor, I can license that same small molecule for other kinds of cancers to other people. So field of use can be a very valuable tool in licensing technology. License geography. So I can limit where you can use my patent. Typically speaking, patent licenses are for the entire world. But there may be very good reasons why you want to license to certain countries but not others. For example, if I'm practicing my own patent in the United States, I don't want to license my competitors. But I know I'm not going to sell in Germany, so I can license someone else to practice my patent there. So a geographic limitation can be important. Sublicense rights. I give you a license. The question is then, can you turn around and license someone else? Right? That's called a sublicense. And there may be very good reasons why I want to give you those rights, because that may increase the revenue to me at the end of the day, because more people are using my patent under an obligation to pay for it. There may be reasons, however, that I don't want to. I don't want more people in the market to saturate it, for example. So sublicensing has to be addressed in any license. Can you sublicense the rights I've given you? Enforcement against infringers. Just like an interinstitutional agreement, if someone finds out that there's infringement out there, who among the licensor and the licensee is responsible for doing something about it? Typically, a license will say, if either party learns of infringement, it will tell the other within a reasonable amount of time. And then it will provide what is done by whom in the face of that infringement. The licensor takes the lead, the licensee takes the lead, they have so much time to do something about it, both will cooperate, et cetera, et cetera. And then finally, payment obligations. The reason I'm licensing you is because I expect that you're going to pay me compensation for the right to use my patent. So, what do those payments look like? Well, it can be a variety of things. Upfront payments. As soon as we conclude this license, you're going to pay me $1 million. Right? Milestones. If it's a pharmaceutical product, when you start clinical trials, you're going to pay me $50,000. You get to phase 3, you're going to pay me $100,000. You start commercializing, you're going to pay me $1 million. Okay? So these are milestones, events that they're payments that are triggered by events. And then finally, royalties. These are typically a function of sales. And it's either going to be a percentage or a dollar per unit or euro per unit number. So again, pharmaceutical product, if you make commercial sales, you're going to pay me 5% of those sales. Right? And oftentimes license agreements, especially where there is an exclusivity, require minimum royalty payments. So once you commercialize, you're going to pay me 5%, but no matter what, you're going to pay me at least $1 million a year. And the reason that that's important is because if you've given away your exclusive rights and they're not doing anything with those, then you've lost the right to license anybody else, and you've lost the revenue stream from the one person that's entitled to do something with it. So minimum royalties are often an important aspect to any sort of payment agreement in a license. So that's it. I want to open up the floor for questions if you have any. Yes, go ahead.
If you do license and then the licensee does not implement, does not proceed with the IP, can you cancel the license or can you do this?
So the question was if the licensee just doesn't bother doing anything with it. So I mentioned the minimum royalties is one. So basically, whether they do something with it or not, they're going to be writing you a check. But there's oftentimes another provision in there that talks about the licensee's obligation to use its best or reasonable commercial effort to commercialize the product. So in other words, it can't just sit on its hands and do nothing, right? Now, obviously, if you don't get regulatory approval, for example, there's nothing it can do, but where it is possible to commercialize, it has an obligation to do so. And if it doesn't, that's a breach of the license agreement. You can terminate it and get your rights back. Sorry. Did you? Oh, you, sorry.
Not the functionality, it might just be a usual functionality, but the concept
Android
might
app.
be an original concept or the problem it's solving. Is there any other apart from patent? Because I don't think patent is applicable.
Excuse me, for what?
For an Android, a mobile application, a mobile app on Google Play,
on your phone.
Oh.
Apple.
Oh, okay. Yeah, I'm not sure that I got it actually because I couldn't hear anything.
So
Yeah. Basically, I wanted to know what intellectual property protection measures are there that I could apply for to protect the concept or the idea or the problem solving of a mobile app for sale on Google Play.
Yeah, well, concept theories are not protectable actually. They can't be object of a patent in a general way. So actually, if there is, we should verify the possibility of protecting them through copyright probably. But actually you can't use the patent instrument to protect it, no. And even if it was actually, if this method is realized through an object, a source code, that is to say, a computer program, a software, or something like this, it's very hard to protect it through a patent unless you can prove the specific unusual function and whatever. So I would say probably just copyright, if applicable, and but I can't see any possibility. It's expressly excluded actually by Italian and European patent law, and I think also U.S. patent law.
What about an end user, like a license agreement, so that no one can copy it? Like, people copy apps quite easily. So if they've used the product and then they've copied it,
Well,
should I have one of those in the app?
So you have to distinguish between several things, right? So again, going back to your original question where you talk about concepts, I can have the concept for an app that allows me to monitor my automatic deductions from my bank account and figure out where, I want to keep allowing those automatic deductions and where I don't. So I have that concept. That's not protectable by anything, okay? But if I write a computer program that I can implement in an app that does that, as Alessandra said, you might be able to get copyright protection, and then if someone copies my code, I could sue them for copyright infringement, right?
But you can't sue them for copying the information or the actual, what's working.
Correct. So that gets me to my next point. We talked about trade secrets and how trade secrets may be the best way to go. What you're describing is precisely an instance where trade secrets may make the most sense, because you've got an app, it works, right? You can license your trade secrets to Apple or Samsung or whoever it is. They can have that app available on their app store. They'll pay you whatever they're paying you. And no one, unless they decompile your source code, I suppose, has the ability to find out what you're doing. So your trade secret protection there Basically, you don't have to tell anybody what it is, and you can't.
And you have to satisfy the other requirements.
That's right.
It doesn't have to be a thing that someone can recreate in an easy way or whatever. So it has to be a very strong idea, let's say, something that is not easily knowledgeable by the others. So it always depends on the nature.
But when they use it, they'll have the information.
Could you please?
When they use it, they'll have the information.
No, they won't. I mean, if you're using, I can sign on an app right now. I don't see any source code.
No, not the source code, the actual what's going on in the app. Like when the user uses it.
But your invention is not what's going. I mean, again, your invention isn't a better way to monitor my automatic deductions. It's the specific implementation that you've come up with.
Yeah.
Right?
Okay.
I can't patent the general concept of what the app does.
idea.
Right.
It's how I've implemented the computer functionality that allows my app to perform in precisely the way it's performed.
Okay. All right. Thank you.
Yeah, not easy.
Anyone else? All right, well, I want to say thank you to Cyprus SEEDS. I think that they deserve an enormous round of applause for having sponsored this. And I frankly can't state strongly enough how important it is to have an entrepreneurial enterprise like Cyprus SEEDS backing the general inventive activities within Cyprus. I also want to thank the Cyprus Institute because frankly their hospitality has been amazing. The facility has been great, and I think that really contributes to the overall success of the program. Finally, the U.S. Embassy, again, I mean, partnering with them was indispensable to this conference taking place. So again, thank you all, and I guess we'll be around for a little while afterwards if you have any individual questions you want to ask.
George, you were asking me about the presentation. Can we have today's presentation?
Yes, absolutely. I think so. So yesterday, today, and Anya's. I know Anya said it was okay to have hers, and then ours from yesterday and today. Absolutely.
So we will be posting everything on the website of Cyprus SEEDS, yeah? But, and we will do so tomorrow, by the way. So please visit www.cyprusseeds.com. And anything else, please contact us. What's an example of email?
Actually, we prefer to think of it as marketing material.